The question here is, I am a foreigner and I will be incorporating a company in Singapore. As I understand, there is a requirement to have at least one local director in the company. The firm that I am engaging, the agency, has offered me to provide a nominee director. However, I have a friend or a relative who stays in Singapore. So, can I use him as a local director of the company? And obviously, the objective is to save some cost. So, let's have a look on this question. There are three key points that you must consider here. The first point is what visa your friend is having while staying in Singapore. If he is a Singapore citizen or a Singapore permanent resident, then he is allowed to take up the nominee directorship. However, if your friend is on employment pass, entry pass, dependent pass, student pass, S pass, or long-term visit pass or work permit, then in that circumstances he is not allowed to take up the directorship of the company. There is one exception to this, and that is employment pass holders and entry pass holders are allowed to take up the directorship only of that company which has sponsored their employment pass or the entry pass. They cannot become director of any other company. So if the employment pass for a person is sponsored by company A, then that person can become or accept directorship of that company A only and not of company B. So if this test is passed, then the next point is if he is a Singapore citizen or a permanent resident, and if he or she is in an employment in Singapore, then is there any restriction in their employment contract which prohibits them from becoming the director of the company? So I will show you a typical clause. Here is a sample clause from a typical employment contract which I am showing you here. So basically what it says is you must not during your employment engage, be concerned, undertake or interested in, whether directly or indirectly, in any business or occupation without the prior consent of the company, or become an employee or director or agent or partner of such a person, firm or the company. So if you ignore for a moment this legal language, what it is saying is basically you cannot be director, employee, agent or partner of any other company while in the employment of the existing company. So what that means is it may require taking permission from the company, and most of the multinational companies, reputed organizations, pharmaceutical, banks and all these kind of companies will not give this permission. And most of the companies and most of the multinational and reputable companies will have this clause in their contract. So it is quite possible that your friend, even if he is a Singapore citizen or a PR, he may be debarred from becoming a director in another company because of their existing employment contract. The third point to consider is your relationship with your friend or relative and the likely impact it may get because of this arrangement. For example, let's say after a year you are supposed to conduct an AGM and file annual return, but you forget to do this. And then Accra sends a notice to your friend that he has failed to conduct the meeting on time, and hence he must attend a director's training program, which is again going to cost some money, and he will have to obviously take off from his job or regular profession for 2 days. Or maybe there are more serious consequences, like you were supposed to file the tax return but you have not filed, and then IRS imposes fine on your friend and he has to pay it because he is a local director. So if all the 3 points mentioned above pass your test, then obviously you can definitely use your friend as a nominee director of your Singapore company. In general, we don't recommend people to involve their friends and relatives in this kind of arrangements.
Thank you for watching this video. This video was brought to you by Epica Consulting Singapore. Subscribe to our channel today to get notified when new videos are posted.